Luxembourg, Modernisation of the Securitisation Law. On the 9th of February 2022, the Luxembourg Chamber of Deputies, Chambre des Députés, adopted the law modernising the Luxembourg law of the 2nd of March 2004 on securitisation, as amended, the new Securitisation Law. The new Securitisation Law enhances legal certainty and flexibility of the Luxembourg securitization regime, while ensuring an increasing effective protection for investors. The new Securitisation Law has modernized the following main aspects. New sources of funding. The financing of a securitization transaction is no longer limited to the issuance of securities but is open to the issuance of any type of financial instrument. Furthermore, in addition to the issuance of any financial instruments, securitization undertakings can have recourse, in whole or in part, to the conclusion of any type of loans, whose yield or repayable principal depends on the risks acquired, e.g. profit participating loans, asset-backed loans. New legal forms. The legal forms that can be used for securitization companies are now broadened by the Unlimited Company, Société en nom collectif. The Common Limited Partnership, Société en commandite simple. The Special Limited Partnership, Société en commandite spéciale. The Simplified Limited Company, Société par actions simplifiée. New authorization and supervision requirements. A securitization vehicle must be subject to the authorization and supervision of the CSSF when it issues to the public on a continuous basis. Only securitization vehicles issuing more than 3 times per year, on an all-compartments basis, non-private placements with a denomination below €100,000 per each unit issued to non-professional investors need to be authorized and supervised by the CSSF. New rules governing the accounting treatment of equity-financed compartments. The accounting treatment and distribution of profits and losses of equity-financed compartments shall now be done on a compartment basis unless the articles of the securitization entity provide otherwise. Where compartments are equity-financed, the balance sheet and the profit and loss account prepared for each compartment shall be approved only by the shareholders of that compartment, unless the articles of the securitization entity provide otherwise. Limitations to the distribution of profits and other distributable reserves may be determined by reference to each compartment, without regard to the global situation of the securitization entity, unless the articles of the securitization entity provide otherwise. The legally required reserve according to the Luxembourg law of the 10th of August 1915 on commercial companies, as amended, shall be determined on a compartment basis without regard to the global situation of the securitization entity, if this is provided for by the articles of the securitization entity. Holding of securitized assets. A securitization entity can now directly own the assets generating the cash flows that are securitized. Acquire such assets or risks to be securitized indirectly, either through a subsidiary or via the acquisition of an entity holding these assets or risks. Security interests. A securitization vehicle can now grant security interests over its assets to parties that are involved in a securitization transaction but are not direct creditors of the securitization vehicle. Active management. Active management of securitized assets is now allowed for Luxembourg securitization vehicles but only where the following conditions are met. The pool of securitized risks is made up of debt securities, claims or debt financial instruments. The securitization entity is not financed by issues to the public. Ranking legal subordination. The following default waterfall of payments order of priority in respect of debt and equity instruments issued by a securitization vehicle is now applicable to securitization entities unless otherwise agreed. The units of a securitization fund are subordinated to the other financial instruments issued by, and loans contracted by, such securitization fund. The shares, actions, or corporate units, parts socials, or partnership interests, parts D interet, of a securitization company are subordinated to other financial instruments issued by, and loans contracted by, such securitization company. The shares, actions, corporate units, parts socials, or partnership interests, parts D interet, of a securitization company are subordinated to the profit shares, parts beneficiaries, issued by such securitization company. The profit shares, parts beneficiaries, issued by a securitization company are subordinated to the debt financial instruments issued and to the loans contracted by such securitization company. Non-fixed yield debt financial instruments issued by a securitization vehicle are subordinated to fixed yield debt financial instruments issued by that securitization entity. New registration requirements. It is now mandatory for securitization funds, and their liquidation, to be registered with the Luxembourg Business Register. Existing securitization funds must register within 6 months after entering into force of the new Securitisation Law. For more information, see our detailed update here.